Hi, this is DEFENZ, the smart lawyer's way. In this video, I am going to bifurcate and explain you in detail about the case of Sunshine Tea House Private Limited versus MTRM Global Private Limited. Let's look into the facts of this case. The plaintiff's brand Chaayos was created and began operating in India in the year of 2012, and it claims to be the largest chain of chai cafes in India with 200 locations throughout the nation. It offers personalized teas in variety of flavors. The plaintiff brought this lawsuit in an effort to stop the rival trademarks Chaiops from infringing upon its registered trademark and using it without permission. The defendant used the mark Chaiops to market goods and services that were identical to those of plaintiff. The important point of contention was trademark. Neither the device nor the logo were an issue. Let's look into the issue involved in this case. The infringement of registered trademark and unauthorized use of trade name by the defendant relating to phonetic and ocular similarity between the trademarks Chaayos and Chaiops. Let's look into the contentions of the plaintiff. The plaintiff claims that it is the largest chain of chai cafes in India with more than 200 locations selling customized chai in 12,000 different varieties. Additionally, the plaintiff has extended out to its customers in areas without physical stores by offering delivery services through its website www.chaayos.com and e-marketplaces like Amazon, Flipkart, Big Basket, Instamart, etc. The plaintiff claims that the defendant violated the registered trademark Chaayos by using the mark Chaiops to market goods and services that are identical to those of plaintiff. Let's look into the contentions of the defendant. The defendant created and registered the trademark Chaiops to sell tea items and run a restaurant or cafe services. According to the defendant, they have established around 37 outlets under the trademark Chaiops. Let's look into the judgment of this case. Finally, it was decided that the defendant will alter its word mark from Chaiops to Chaiops. The learned counsels of the parties were asked to prepare agreed upon conditions of the settlement and present it to the court. The court is of the opinion that fair amount of time will be given to the defendant to carry out changes to its current center's physical board stationery, and that the change would take effect immediately for any new outlets or online platforms. Within 1 month from the date of settlement, the defendant must take down, remove and delete all posts, videos, photos, reels, etc. bearing and referencing the current trademark Chaiops that were published by the defendant on social media platforms, but it is not limited to Instagram, Twitter, LinkedIn, etc. Within 1 week of receiving this notification, the defendant must remove all signs, posters and other materials, whether offline or online, or they will be held liable for damages of Rs 50,000 each day that default persists. The plaintiff didn't pursue damages and rendering of accounts due to defendant's commitment and assurances. The parties must agree in writing before disclosing the terms of settlement to any third party. Let's look into the review. In view of the above judgment, the court wanted an amicable resolution between the plaintiff and the defendant. The court asked the plaintiff not to raise any issue regarding the use or registration of the new word mark Chaiops or any variations before any court or quasi-judicial entity. Thank you for watching this video. Do share and subscribe. Stay lobbyfied.